Good afternoon, everyone. I'm Gene Block, Chancellor of UCLA, and I'm very pleased to welcome you to this important event. The centrality of immigration to the growth and success of the United States is, of course, well known. Beyond the fact that immigrants have been vital to the history of our nation, state, and region, they are essential to our future. That fact is too often lost in the political climate marked by rising xenophobia, stereotyping, and racism. In this fraught context, it's even more important that we affirm the extraordinary value that immigrants bring to this country, as well as asserting our commitment to the dignity, well-being, and prosperity of all. Such a commitment was demonstrated in 2020 with the establishment of the UCLA School of Law's Center for Immigration Law and Policy. The center's mission is to conduct deep and meaningful inquiry into our current immigration laws and policies, and to consider how they might be adjusted and improved. Building on our expertise and our deep roots in the community, the center has been a critical source of scholarship and insight for community organizations, lawyers, policymakers, and experts throughout California and the nation. These partnerships and the center's work will remain essential in the years ahead as issues related to immigration continue to occupy a central place on the national agenda. I'd like to give a warm welcome today to United States Secretary of Homeland Security, Alejandro Mayorkas. With all of your and the new administration's plans, Secretary Mayorkas, we're very grateful that you made time to join us at this event. I worked closely on immigration issues with one of your predecessors, Janet Napolitano, when she was UC president, and I look forward to working closely with you as well. We hope to host you on campus in person soon and to collaborate on important issues of mutual concern. I'm now pleased to introduce the Dean of the UCLA School of Law, Jennifer Manookan. Dean Manookan, who has led our law school since 2015, is also a leading evidence scholar and the founder and faculty co-director of our program on understanding law, science, and evidence. Her intellectual vigor and strategic leadership have made her a great partner and ensured that the UCLA School of Law remains engaged in the issues that matter most. I'm happy now to turn the program over to her. Thank you.
Thank you so much, Chancellor Block. Thank you for those welcome remarks and for joining us today and supporting our law school programs, including, of course, the Center for Immigration Law and Policy. I also want to thank you for your tremendous leadership at UCLA, especially during these extremely fraught and challenging times. As Dean of UCLA Law School, I get to do a lot of terrific things, a lot of fun things, and the introduction of today's special guest certainly ranks high among those. It's my great pleasure to introduce Alejandro Mayorkas, who currently serves as the Secretary of the United States Department of Homeland Security. He assumed his post 3 months ago, and he's already been at the center of a number of decisions and events that hugely impact the lives of refugees and immigrants to the United States. Secretary Mayorkas is the first immigrant and the first Latino to serve in his position. And I expect that his background, in addition to his decades of professional experience in immigration and citizenship, will give him an important view into the issues at the heart of this conference and into his role. I very much look forward to hearing more from him in just a moment in conversation with UCLA Law School's Ahilan Arulanantham in just a moment. Secretary Mayorkas and his family fled the Cuban Revolution as refugees when he was a child. He and his family eventually settled in Los Angeles, where he grew up. He attended Beverly Hills High, UC Berkeley, and Loyola Law School. In 1998, he was appointed the U.S. Attorney for the Central District of California here in Los Angeles by President Clinton. Then, under President Obama, he served as the Director of U.S. Citizenship and Immigration Services, and later as the Deputy Secretary of the Department of Homeland Security. He also spent a substantial amount of time in private legal practice during his career. Now, for some of you in the audience, especially those who are part of our UCLA law community, his last name might ring a bell. If that's true and you're thinking about the Mayorkas name, well, yes, you are onto something. His sister is indeed our much beloved and now retired, although she's been helping out around the law school back on recall, Kathy, the one and only Kathy Mayorkas, who ran our public interest program here at the law school for many years. Needless to say, any member of the Mayorkas family is very much welcome here at UCLA Law School. And so it gives me an additional pleasure on that score to welcome Secretary Alejandro Mayorkas. Thanks so much for being with us today.
Thank you, Dean Manookan. I am, it's an honor to speak with everyone and to frankly participate with Ahilan and the wonderful center here at UCLA. And it's my pride to follow in the shadow of the one and only Kathy Mayorkas. So thank you so much.
And Mr. Secretary, before we begin, I just want to thank you again. It's truly unusual and an important statement about transparency in government that you're willing to come here and have this conversation with me. So greatly, greatly appreciate that. I also want to say, I said this a little bit in the morning, but we did have a discussion with your staff and shared some of the topics in advance. I suggested also maybe even sharing some of the setup questions, and you rejected those, saying that you wanted the conversation to be free-flowing and organic. So let me jump in then, if that's okay with you.
I look forward to it, Ahilan. Thank you.
So upon your nomination, November 23rd, 2020, you tweeted, "When I was very young, the United States provided my family and me a place of refuge. Now I have been nominated to be the DHS Secretary and oversee the protection of all Americans and those who flee persecution in search of a better life for themselves and their loved ones." For me, I was almost brought to tears when I read that, in part because I was born here, but I'm also from a refugee community. My family's Sri Lankan Tamil. So it was extraordinary to hear that kind of statement coming from the DHS Secretary. Now we're 100 days in, and there's a reality, I think probably we'd both acknowledge, a sad reality. If your family or mine, my relatives, came to the US today and sought asylum, if they were adults or even in a family group, they would most likely be expelled without even an opportunity to apply for asylum under Title 42. I assume you can't be particularly happy about that. Can you give us either a time frame as to when that might end, or at least what metrics might be used to determine when Title 42 expulsion will end?
Ahilan, let me start by assuring you and everyone that the use of Title 42 is not a source of pleasure, but rather, frankly, a source of pain. But it is something that is compelled by the reality that we are rebuilding an asylum system in a COVID environment. And we have other challenges as well, as we inherited the dismantlement of our operational capabilities to administer our nation's asylum laws. The only thing I can assure you is that our reliance on Title 42, the expulsion authority, which is a CDC authority and a public health imperative, our timeline is as quickly as possible. And quite frankly, your old employer, the American Civil Liberties Union, is suing us for our use of Title 42, and has given us an opportunity, not much of an opportunity, I should say, and correctly so, frankly, and nobly so, to manage through the pandemic while pushing the limits of our asylum capabilities to their maximum. So they're making sure that as soon as possible is sooner than we think possible.
When you say that's very helpful, insight into some of your thinking on this, it seems like there are two things that you're talking about in terms of when the US would be ready. One is about the ability to process asylum seekers, and the other to rebuild the system that you say the Trump administration dismantled. And the other seems to be about coronavirus or public health considerations. Are there metrics that you can look to for either of those? Like, for example, for the latter, or go ahead.
No, let me explain, because they both contribute to the public health imperative. What we are managing is we're managing against the restrictions on congregant processing, right? We cannot have individuals in close proximity to one another in a very condensed space for an extended period of time by reason of the pandemic. And so that's the public health imperative. And why the dismantlement of the processing capacity that precedes us is relevant to the public health imperative is we have a system, personnel were moved, processes were changed, policies were changed. And so in a dismantled environment, there's a greater likelihood of individuals in close proximity to one another for a longer period of time. So as we rebuild the efficiencies that we once implemented and enjoyed, the COVID pandemic is more looming. That's just the reality of it.
Right. Yeah, that makes sense. I assume over time, schools will reopen, indoor dining, people going to basketball games inside of stadiums. And as those things open more and more, then presumably the risk associated with what you're talking about people having to be socially distanced in CBP facilities or whatever it is, would decrease. So are those sort of relevant to figuring out when Title 42 will end then? Well,
I think, other venues, it's a very fact-specific inquiry, but there's no intention to use the CDC's Title 42 authority for a day longer than the public health imperative requires. And what we have done, quite frankly, and I think it's something to remember, is we have made a decision to put more pressure on ourselves because of what we consider to be a humanitarian imperative. And that is to not exercise our Title 42 authority, the CDC's Title 42 authority, with respect to unaccompanied children. And what that has done is created a tremendous amount of pressure as we process those children through our system and through a system that we are rebuilding post-dismantlement, and the pressure of congregant space, as we have seen through very powerful and heart-wrenching pictures, it's put a greater strain on us. But we drew a line, a line in the humanitarian environment that this we just cannot do.
Yeah, so I watched that press conference and I saw someone say to you something like, well, this is just the Trump policy. And you said, no, because we're not applying it to children. We're not going to expel unaccompanied children into the desert. It's not who we are. I found that also extremely moving. And having represented children in other litigation, which I want to talk to you about now, since 2014, I found that also very moving. But as you say, it creates other headaches. So I want to ask you about sort of something specific to that. As you say, there's thousands of children coming. DHS is also putting those children into removal proceedings. In 2014, when we had a similar situation, that led to a lot of unrepresented children going to immigration court without legal representation, and tens of thousands of them were ordered removed in absentia. And again, I assume you would not have been happy to see that. Do you have thoughts on how you would prevent a similar situation from happening now?
So we are very, very focused on the well-being of those children, not only Ahilan, as we process them to HHS and then unite them with their parents or other sponsors here in the United States, but also with respect to their rights to seek relief, either in our asylum system or through court processes in the special immigrant juvenile status. I consider the immigration prosecution of children without counsel to be unacceptable. So we are very focused on not only doing everything that we can to assist them in obtaining counsel, but also you will see, everyone will see us promulgate policies that impose upon our own lawyers the obligation of caring for the rights of the children who are on the other side of the courtroom. our responsibility is to do justice, and to do justice for the unrepresented as well. And when a child is unrepresented, what that means for a government lawyer is not by any stretch an easier case, but quite the contrary, a more difficult case, because now not only must we ensure that the rights and obligations of the government are adequately addressed, but the rights and access to relief for the children are adequately presented to the court. That is as much our obligation as anything. And as a matter of fact, we cannot fulfill the government's responsibilities without ensuring that the rights of the child are well represented. And therefore, a government lawyer has a lot more to do.
So I thought you were saying at one point that you were assuring us that children would not be forced to proceed without representation in immigration court, but then perhaps you were saying that it's the duty, you want it to be the duty of the trial attorney, the prosecuting attorney, to protect the rights of the child. Can you clarify that?
Yeah, and I'm sorry if I wasn't clear. Look, the law is not, as it is currently applied, and you know this very well, that an immigration proceeding with respect to a child cannot proceed unless that child is represented. And so we will work with organizations, with institutions, both public and private, to do everything we can to make sure that a child is represented, very often by community-based organizations, KIND, for example, Kids in Need of Defense, through law clinics, through pro bono counsel and the like. But when a child is otherwise not represented, then it is the obligation of government counsel to make sure that the arguments that a child might have in furtherance of relief are actually presented to the court.
So you mentioned special immigrant juvenile status earlier. It's an incredibly important form of relief, as I'm sure you know. A huge number, it's sad, but a huge number of the children coming here to our borders had one or both parents completely drop out of their life, which is awful, but also creates a possible avenue for relief through special immigrant juvenile status. But you have to go to state court to get that. And one of the things I noticed when litigating this issue, just several years ago, was that it just never happens that an unrepresented child has some person go to state court. Right? It's inconceivable, right? That an unrepresented child could do that. And it also seemed like something that even very well-meaning immigration judges, very well-meaning trial attorneys, they couldn't do that either. They couldn't go to state court either. So I'm not sure I have a question to say, just something for perhaps you to think about. I mean, in the sense that you obviously do have a deep concern for justice for these children. But I do think it's extremely difficult for that to be reality absent representation. And obviously, yes, the law doesn't require it, but you, Mr. Secretary, you could require it if you wanted.
So Ahilan, let me, I'm not sure I understand the problem of children unrepresented in the court, outside of the immigration court context, to pursue SIJ status. Are you focused on the fact that they're not led into that court because because counsel is not there to steer them in that direction? Or is it the fact that they're just not represented in the court?
So you mentioned KIND and immigrant, there's a number of organizations, they routinely go to state court to get the order that's needed for the state court judge to verify that the child has been abused, abandoned, or neglected by one or both parents. If you don't have a lawyer, if you're an unrepresented child and you don't have a lawyer to go get that order, then special immigrant juvenile status is unavailable to you. And if it's unavailable to you, then the promise from this very protective humanitarian law that Congress established is just, it's meaningless. And so that's my sort of basic point, that it seems like you cannot actually protect children in this situation without guaranteeing their representation. And it does seem like that's something that the DHS would have the power to decide, to choose only to proceed against those children who are represented and put the ones that are unrepresented at the back of the line, basically?
That is a profound policy question that, quite frankly, I have not delved into, which is really, Ahilan, what you're saying is not pursue the removal of a child who is unrepresented because the rights of that child will not necessarily have been advanced, because we have in the immigration court, I think we can address that through responsible government counsel. But what you're saying is there's a whole other avenue that may not necessarily be exploited in the best sense of the term, and that's the court system in the SIJ process because of that lack of representation. That is something I need to look at.
Well, I have to say, just knowing you and the way you have run things, it gives me great comfort to hear you say that, because I know that you will. Let's move on. I want to talk about temporary protected status a little. And I know it's a little complicated because I still represent plaintiffs in litigation about that, and you're the defendant. And we won't run the settlement conference right here live on national TV. But I still want to see if there's anything that can be said. And if not, absolutely will not feel at all unhappy about that. The president's campaign website, which is still up, joebiden.com, it says that he would order an immediate review. That's the language used, an immediate review of the Trump era TPS terminations. And I know you're familiar with this, but for the many viewers who might not be, we're talking about 400,000 people, most of whom have lived here for more than 20 years lawfully. They have several 100,000 American born children, many of whom are school age, some of whom are now hunger striking in Washington, or I think they might have finished that today. And they're nervous. I talk to these people regularly as part of the case. They wonder if that promise is going to be kept because it's been 100 days. Can you say anything I understand, very constrained here, I understand, but is there anything you can say to reassure them about whether the president will keep that promise?
So Ahilan, I appreciate both the acknowledgement of the constraint and also the acknowledgement of the gravity of the issue and the needs of the people. The administration, we have taken some actions with respect to temporary protected status. There are other nations, the people who are resident here in the United States who are seeking TPS, as to whom we have not made a decision. And all I can say is that the country conditions are very much under review. That review is ongoing, both with respect to the countries that are of higher profile than others, Haiti to be a very powerful example, and some countries that quite frankly may not necessarily be similarly on the radar, but that we are taking a look at, whether it's Cameroon or Mauritania or others. So we're very mindful of the campaign promises, but more fundamentally, we're very mindful of the fact that the conditions in those countries deserve our close review, and that review is well underway.
Thank you. Thank you. Let me switch gears a little bit. We had a panel 1 week ago on activists, and it was sort of centered around this film called The Infiltrators, which is a fabulous film. It's a half documentary, half real sort of fiction about these undocumented youth activists during the Obama administration who deliberately got themselves arrested to go into detention centers in order to then document that there were people there with no criminal histories whose presence seemed in tension with the Obama administration's stated account of its enforcement priorities. Then the film came out and the election happened, and we're under the Trump administration, and the Trump administration targeted people, activists, for deportation, including actually one of the people in the film, Claudio Rojas. And he had been on an order of supervision, was checking in for a long period of time, and then was deported suddenly, order of supervision revoked, and was deported even though nothing had changed. I mentioned him, he's sort of paradigmatic. We're not talking about like hundreds of thousands of people, but there are, I think at least dozens of people who were immigrant activists who were targeted for deportation. It seemed very clear that it was in retaliation for, in his case, promoting the film. So I have sort of two questions for you about this. The first one, I saw even today that there were people protesting outside the White House, immigrant activists. Can you assure people, now it's a new administration, that ICE is not going to retaliate against people, to move them up in the line, sort of prioritize them if they speak out or protest in favor of immigrants' rights?
So that let that be the easiest question that you asked me in the time that we have together. Of course, that is unacceptable. I think we should probably delve into something more difficult, which is the detention system itself. Retaliation in response to the constitutionally protected right of free speech, and quite frankly, the obligation, the civic obligation to protest government positions with which one disagrees, that's just unacceptable. Frankly, I find other aspects of the detention system writ large to be unacceptable. Some of the conditions that define the manner in which people are detained, the bases of detention. I grew up in my government service as a federal prosecutor. We had two bases on which to seek the custody of an individual pending the disposition of criminal charges, threat to public safety, or risk of flight. Those seem like reasonable predicates for the detention of an individual in a civil immigration proceeding, and I don't know why we approach it so differently. And I think that the public will see detention policies promulgated in relatively short order from this day forward that speak to significant and much needed reform.
So I'll definitely take you up on your offer to talk about detention with you, and I'll do it in just one second here. But let me just ask one more question about this issue about the activists. And I think for me, it has sort of outsized importance given the number of people involved, because I think when people can protest, particularly directly impacted people, when they can protest freely, it creates all kinds of political space and momentum which may not otherwise exist. And that's certainly true of the infiltrators. But now we've got the situation where there are people who are abroad, like this guy, Claudio Rojas, his wife and children live in Florida, and he's in Argentina. I know in other contexts, like family separation, the administration has created processes whereby the office, I think it's your office or an office related, anyway, some very powerful set of people are reviewing cases. Would you be open to something like that, reviewing cases of potential retaliation and then bringing back people who were victimized through parole or some other mechanism? Because that would send the message, right, that what you just said, we're not going to punish you for protest, that message is real.
So truth be told, Ahilan, when you made the point that you did with respect to the community of people who were the victims of retaliation, or reportedly the victims of retaliation, I do owe it to my colleagues in the department to give them due process with respect to the basis of the removal. And I have not delved into the evidence, and I do believe in doing so. But to speak with Michelle Brunet, the brilliant and extraordinarily committed individual who's joined the Department of Homeland Security to lead the Family Reunification Task Force, to speak with her about the community of people who might have claims of retaliation, and to see whether we can look into those as part of our overarching effort.
I greatly appreciate that.
But I'm gonna make decisions on the evidence, and I believe in process, and so I do believe in giving the agency the opportunity to communicate facts that it believes are controlling, and we'll take it from there. And I don't shy from difficult decisions.
So let's switch gears then and talk about detention. And I definitely want to talk about danger and flight risk, as you just discussed. Let me start with something just a little bit different. There was a rally in Georgia yesterday. I'm guessing you've heard about this. When the president referenced, there were some protesters shouting on the side, and the president referenced a desire to end all private immigration detention. There's an executive order to end contracts for all private prisons, criminal system, but there's not an executive order currently anyway on private immigration detention. Is that something that you would favor, ending all private immigration detention?
That's something that I think I owe it to the president to deliberate internally before speaking externally.
Absolutely understood. So we had a panel on detention as well in the first week, and it even included a former Obama administration official who worked on detention. And starting with public safety, I'll say nobody would defend it on public safety grounds, even the former Obama administration official. And the basic reason for that was that the people who are coming there labeled as public safety threats into immigration detention have all finished serving their time in prison. So if they were born in the US, the approach of the law would be reintegrate this person into society, take them back to their family, give them, rehabilitate, give them the supports needed to survive and thrive. Obviously, it doesn't always work that way. It doesn't always succeed, but that's the sort of theory. And it seems like just because they're born abroad, they don't get that. And that seems unfair. So it both seems unfair and also doesn't seem like, it seems an odd public safety rationale. If essentially you're saying, if you're a citizen, then we do this thing. If you're a non-citizen, now you're a public safety threat. I know you disagree with this.
Fundamentally, so.
So yeah, and I want to give you an opportunity to tell us your views on that.
So and I can bring it to life through a real case, anonymized, of course. But let me just ask a question. So an individual, a single male, enters the country unlawfully, okay, without a legal basis under the laws as it currently stands, 7 years ago, and commits a series of crimes, some quite violent, does his time. By reason of the fact that he's done his time, he's allowed to stay here in the United States? Is that the proposition?
No. I would say the fact that they committed the crime should have no bearing on whether they should be detained.
So let me take that on. Okay, so it's a detention specific issue. So they should be released until such time as they are removed.
Whether or not they should be released should turn on whether they are a risk of flight, and a risk of flight that can't be satisfied through other methods.
Only.
Not whether or not, right, because as I said earlier, the public safety threat that this person poses is not different from the public safety threat of the person next to them in the cell who was born here but committed the same crime and had the same offenses.
But that's because we cannot detain the person. Let me just articulate my view, and let me indeed bring it to life. An individual enters the United States unlawfully, without a legal basis, in between the ports of entry at the age of 19, commits a misdemeanor sex offense, does a short period of time, and is not removed. And why the individual is not removed, I don't know the facts, but did a short period of time. Commits a second misdemeanor sex offense within a matter of 24 months after release, and does more time and is not removed. Reasons I don't understand. And then within 24 months of that release, commits a felony sex offense, the forced prolonged penetration of a 14-year-old girl. A rape. And that individual does his time, I will not release that individual pending removal proceedings. Because I have an obligation, number one, to enforce the law, and number two, to enforce the law in the service of public safety. And I might not have the opportunity in the criminal justice system to continue the incarceration of that individual if that individual was a United States citizen, because that individual completed what the law provides. But I have a tool at my disposal with respect to an individual who unlawfully entered the country, who is a recidivist, and who in fact poses a very significant threat to public safety, because there is no evidence whatsoever of an intention not to commit a fourth offense. And so I'm going to protect the public. And by the way, that individual tends not to victimize minors in Bel Air and in Beverly Hills, but in the very immigrant community that we all serve. I must tell you, I feel very strongly about this. It is a tool that I have at my disposal. It is a tool that I feel obligated to employ for the reasons I've articulated. And none of us on this call would want that individual residing in an apartment 2 doors down from our residence as we kiss our child, as the child leaves the residence to walk to school.
Well,
I'm going to, and yes, there is a distinction between a United States citizen who commits offenses and what the law provides, and an individual who enters our country unlawfully and commits serious offenses and poses a continuing threat to public safety.
Well, something tells me that I'm not going to persuade you to change
No, but look,
So,
well, I've been passionate about other issues and have been persuaded that I am errant in my in the direction of my passion. So strong-minded does not necessarily, it does not mean close-minded, but I will tell you, you will have a hill to climb here.
Well, I completely appreciate that. I think my sort of preference would be to say, let's agree to disagree on the case that you just described and whether it's justified in that instance to treat the nonsense.
But I'd love to, but Ahilan, I'd love to hear your reasoning, and it's not, well, I would not find persuasive the reasoning that, well, that's not how we handle a recidivist US citizen who has had multiple counters. That I don't find persuasive.
Well, to me, there's a judge who sentenced that person, and the judge was operating under criminal laws that were created by the people of the state of California or whatever state. And that judge believed within the constraint of that law that that was the appropriate sentence. I mean, one of our panelists last week was Nia Norn, who's now quite an effective and extraordinarily powerful advocate for a group called Asian Americans Advancing Justice. She spent 30 years, 16 years in prison for an offense related to a murder, and then 6 months in immigration detention. And then a judge thought that she, and the parole board thought she deserved a second chance, and they were right. So, I mean, to me, that's the sort of argument about it, but I really don't want to, I entirely understand your position. It's a position
and by the way, this individual is going to be removed.
Right, right.
I'm not going to, yeah.
Right. Understood. I guess my sort of thought is, I totally understand that people could have a view as yours does as to these sorts of cases. The danger that we've seen sometimes in the past is, you take Willie Horton and you end up with mass incarceration. And you take the example of sex offenders, murderers, and things like that, And then you end up with a system with clients like mine, people being detained as dangers when they've lived in the community for 20 years without having committed any offense, or people arrested and detained as dangers for drug-related offenses and things like that. So I guess my thought is just whether in the enforcement priorities, which I know your department has now created, there's an attempt to sort of focus on trying to narrow it to these most, the most extreme cases.
So Ahilan, I mean, you make a very, very important point, and I want to echo it if I may, because I won't disagree with you about the overuse of detention and the miscategorization of individuals as public safety threats when I would judge differently, and I'm now in a position to execute on my judgment. So those are, I think, are very, very different things. The case that I presented and the rationale that I presented versus an individual who, and we've reviewed this, but 24 hours ago, an individual who's been in immigration detention for over 500 days and has not had any encounters with the criminal justice system. That is a misuse of detention, in my opinion. And the enforcement guidelines, by the way, are interim to date because they were promulgated before my arrival. I worked to revise them, but they remain interim guidance, and I will be engaging with the workforce, and I will be engaging with the different voices in the community to promulgate the final guidance, including guidance that defines the use of detention for when it is appropriate to serve the public safety imperative.
Thank you. And I look forward to seeing those in the time to come. Let's switch gears just a little bit, although it's not that far afield, I think. Race discrimination and its relationship to immigration enforcement is an area of particular interest at the Center on Immigration Law and Policy. And obviously it's been on forefront of many people's minds in the recent past. I was struck by President Biden after the conviction of Derek Chauvin for the murder of George Floyd. He said, and he said something similar yesterday as well. He said, we must confront systemic racism in the criminal justice system. And he called it a stain on our nation's soul. Now, ICE enforcement, some of what you've been defending, although not the way that you've defended it, but a lot of ICE enforcement relies on those same state criminal law enforcement systems, right? By making them the primary pipeline to detention and deportation. It does seem to be particularly harsh on Black immigrants. They're 7% of the immigrant population, but they're 20% of the criminal deportations. This is, I'm sure, intractable in many ways. How do you think about this problem?
I had a very, very thoughtful discussion, a very provocative discussion with advocates in New York City on this very issue just a couple of days ago on Wednesday. I think that we have an obligation within our limitations, and I'll speak of that in a moment, Ahilan, to not perpetuate the injustices that really are in the criminal justice system, that we do not perpetuate them, because in fact we do rely, and maybe not in the case that I identified, but we do rely on criminal justice records in making our public safety determinations that drive our immigration enforcement actions. So we do inherit the criminal justice system for better or for worse in many of the decisions that we make. We have an obligation not to perpetuate the infirmities and the stains. At the same time, we do have some limitations. So I receive every week reports of apprehensions. We regret, they are they're numerous, and we do not have the capacity to investigate every criminal conviction that an individual in removal proceedings who has been apprehended has had to determine whether that criminal conviction is born of or infected by racism. We just don't have the capacity to do that. We can't do a 2255 proceeding in every case. But if there is evidence of infirmity, then I think we have an obligation to delve further into it. And how to operationalize that is something that is incumbent upon us to figure out.
And just for our listeners, a 2255 is a way of coming after the conviction to take a look and see if there's a defect in the underlying conviction. And there's similar in the state system, of course. What do you think? So it's very heartening for me to hear that you see that and see perpetuation as also a problem, which I think is very important. I understand that it's very difficult, probably even if you had all the resources, it might be quite difficult in many cases to figure out individually in an individual case level whether racism had infected the process. What do you think about doing it by reference to whether a jurisdiction itself has been targeted perhaps by the DOJ as one in which there are problems involving race discrimination, whether systemically through DOJ or it could be through other entities. I'm thinking in like Maricopa County, for example, Arizona, from back in 2010. But you could imagine other situations like this too. The Ferguson a police department that was investigated by the DOJ, for example. One idea, it seems to me, is that ICE could choose not to rely on criminal convictions from the state system as a pipeline where there's a jurisdiction which has been found or is, to have these kinds of problems. What do you think about that?
So I have not thought about it. It seems sweeping. It seems quite sweeping. And my visceral reaction to that, and my immediate, I should say, reaction to that is too sweeping. And interestingly, Ahilan, I don't know that the Department of Justice, when it has undertaken a pattern and practice investigation of a police department and has found problems and has entered into a consent decree with the police department, whether it has, as a matter of course, then determined that for the period of time that it investigated and determined that the police department was afflicted with problems and fundamental problems, that it said it would look at all of the criminal convictions that were born of the police work of that department during the relevant time frame. I don't think they have done that. Mm-hmm. For reasons I can well understand. And so for those very same reasons, I think such a rule would be too sweeping. I think that we will need to figure out how we protect the immigration system from perpetuating problems in the criminal justice system. And my ethic is to not figure out those problems in isolation, but to figure them out in collaboration with voices such as yours.
I appreciate that. And I'll ponder it more too, because I admit that it's hard. Yeah, it's an intractable problem. We just have a few minutes left. Let me shift gears slightly, but it's sort of in the same sphere. Local law enforcement, sanctuary cities, the relationship between ICE and state and local entities. You were quoted in the Washington Times but I'm not totally sure that the way it was written, the quote was accurate. So, as it was written, it said that one of your, or implied that one of your significant priorities was to educate city officials on sanctuary city policies, which I took from the context to mean that you wanted to educate them to end sanctuary city policies. But as I said, I'm not sure that's what it said. So my first question is that right? Is it your goal to sort of end sanctuary city policies? And then if so, I have some other questions.
This will be a return to a point that we previously discussed in some way. Here is my approach, and the dialogue is so infected by the challenges of secure communities, and I think the view by many that the priority enforcement program that succeeded it was an old wine in a new bottle. Here's my fundamental view, and I know this will not be received with unanimity. I have that 26-year-old single male whom I described with the 2 misdemeanor offenses and the felony offense is in custody, is in state custody. And we're facing the release of that individual. I do not believe that that individual should be released into the community so that ICE's fugitive operations has to go into the community to find him, apprehend him, and place him in detention pending removal. I think that the state facility should turn that individual over to ICE directly. And I think that is a public safety need. And I think that that is a cooperation that should be achieved, and that it is my responsibility to see that cooperation modeled, and at the same time end the relationships that are pernicious or serve a pernicious need. And I think we can do both.
So, and I think it sort of relates in a way to my sort of half-made earlier point that, you know, you don't want to use Willie Horton as a basis for making a broadside of public policy. And I worry a little bit about, you know, if this is the person who's in our head as we kind of think about all the policy that should happen, that it can be distorted. Secure communities rollout, I think, is a great way to think about that. In some ways, an illustration of that, because there have been empirical studies about whether secure communities actually decreases crime. And I've looked at several of them. They're very rigorous. And they seem to show it has no effect on crime, has no effect on public safety, which suggests that I think that the person you're talking about either is extremely rare, or that the judgment being made about whether that person is actually a threat may actually be extremely difficult to make, and so difficult that the harmful effects of deportation, it harms the children of that person, not the person you described, but a person who has children, a person who it tears apart that family, that also is bad for the community and undermines public safety, and that the net effect of it is actually a wash. But I'm sure, I guess my question is, are you aware of this? Would data matter in this context? Would it make a difference?
My gosh, can you imagine if I said that data didn't matter?
Oh, but
look, I mean, of course it matters, and I've done extensive reading on secure communities. The real answer isn't the real answer that an element of the answer that we don't make decisions in individual cases based on categorical assumptions, but rather we make decisions in individual cases based on the facts and circumstances of the individual case. And we exercise our discretion wisely and appropriately in an individualized manner. Isn't that where we need to go? And all too often, by the way, I was a prosecutor at a time of United States sentencing guidelines that were mandatory. and they made categorical decisions. And I encountered many instances where those guidelines created injustices, tragic injustices. And so we need to move to a more individualized determination model in the immigration arena.
Right. Yeah, I think that in that context where you're talking about an ICE agent trying to work with a jail or someone who's arrested, and having that person make detailed, reticulated, individualized assessments, at least in my experience seeing these in Southern California, they often didn't come out right. And that may be the reason why I sort of go back to, but we know that if you deport the person, you're taking a person out of a community. But you know, it's a complicated question. Secretary Mayorkas, I think that given the television sort of requirements that we cut off right at 1, maybe somebody can correct me if I'm wrong, but I think we're actually out of time. Is that right, Dean Manookan? Or do I have time to ask one more question?
I think you might have time for one more very quick question.
Okay, and then I look forward to part 2. Ahilan, we have a lot to discuss.
Yeah, let me first, before I ask it, just say, I'm so grateful to you for coming to do this. And I think it's an extraordinary sign of both transparency, and also it's just remarkable that somebody who is the DHS secretary has such a breadth of knowledge on so many issues and so many more that I don't know about enough even to ask you. And it's extraordinary that you have been willing to do this. I hope it would be something that lots of government officials would do if they had your knowledge. The last question I'll just say is very, very quickly, we just filed a brief in the Supreme Court about the illegal reentry statute 1325 and 1326, and about how its origins, it was enacted and then enacted in 1929, reenacted in 1952, as explicitly a mechanism of white supremacy, as a way of keeping out Mexicans because they would dilute the racial stock of the United States. I'm sure you would have, I know you litigated 1326 cases, I defended them. I had no idea of this history at all. And I guess my last question to you is that something, have you ever heard about this? Would it change your views in any way about whether and the extent to which 1326 should be used?
So I'm not familiar with that history at all. And I believe in the use of 1326. I don't know 1325 as well. But I know one element of 1326, which is the element of an individual having criminal liability for the illegal reentry into the United States following a removal subsequent to a felony conviction. That is the area that I'm involved in. And of course, if the individual whom I described had been removed in between one of the misdemeanor offenses and one of the felony offenses, I might have sought to use that statute. I was not aware of its racist origins, and those statutes need to be used quite advisedly and certainly not in the way they were used over the past 4 years.
I'm going to jump in here with a just enormous thank you to both Secretary Mayorkas and Ahilan for what's been just a terrific discussion. Secretary Mayorkas, thank you for taking time out of your busy schedule. Thank you to both of you for participating in a tremendously substantive conversation about these critically important issues, and for the transparency and the engagement that this conversation has provided. Thanks to everybody who tuned in to participate in this event. To those watching, please don't forget that the UCLA Law School's Center for Immigration Law and Policies conference continues with another insightful panel at 2 p.m. Pacific time this afternoon, and another full program next Friday. So please join us for those, and please join me in giving Secretary Mayorkas a just tremendous round of appreciation for being with us today.
Thank you. Thank you for the opportunity. Thank you, Ahilan. Thanks, everybody.
Thank you.